My people, my ear don't hear, my mouth won't speak. Una know for all these things where they happen, so lawyer don't come out come dey ask questions. Say first of all, why they judge that case on the 6th? He said because he say on the 6th na bad. Now go hear am later. He say, however, they still discuss and say judges, they're not supposed to come to the arena, because when you come to the arena, you come to feel things. You come like say they're supposed to judge, like judge. And you can't talk one thing. He say he hope say Supreme Court go choose another date since again. I beg Mona watch, because this story, But what is really happening in Nigeria? I always ask this question, and I'm waiting for it in your comments.
Might affect the public perception of the judiciary, and of course your thoughts on the judgment as a whole. We'll start with you, Mr. Chris.
Good morning, Shay. Good morning, Akeredu. Let me say clearly here that your question captures the mood of the nation. Your question captures the sentiments. Your question captures the perception of the people due to what happened on the September the 6th, 2023. And I say this advisedly. Maybe Mother Providence had its own predilection, permit my choice of word, when the judgment was fixed for the 6th. In metaphysics, 6 is the number of man. Man has his own tendencies to disappoint, if you like, his frailty. And in this case, not wanting to stand by and for the truth, And interestingly, I hope that when the matter gets to the Supreme Court won't choose another 6th, number 6, to disappoint the people, because the issues are very lucid. They are fundamental issues, and in law, we're taught as young students in law school that judges do not descend to the arena. They don't grant prayers you do not ask for. And let me say clearly that in one of those very funny paragraphs in the judgment, the judges came down to the arena. They did say about a certain witness from the Labour Party that she was a party member, the lady from Amazon, that they cannot admit her evidence because she's a member of the Labour Party. And then turns, on the other hand, to admit the evidence from a sitting senator, from a member, a reputable member of the APC, my brother and friend, who is presently the majority leader of the Senate, Bamidele Okpeyemi. That's, on the one hand, admitting that clearly, if you like, maybe it was the voice of Esau and the hands of Jacob, or vice versa. But let me say clearly, as I talked to you this morning, what is important is that, like we said before the judgment, all eyes were on the judiciary. It was the judiciary that was on trial. We have seen the certified true copy of that judgment, and clearly on the top of it, the header, I don't know why they made that mistake. The judgment, as it were, assumedly proceeded from the APC presidential legal team. And you could see when the judges were reading it, they were not reading a judgment that was indigenous to them. They were not reading a judgment that they could own. They were, if you're reading your speech, you make very little mistakes. But when you're reading a prepared speech, a written speech, of course you could see it. Everybody who watched that, the longest, if you like, the longest judgment we've seen in our historicity, would understand that it was clearly about the puppet and the puppeteer. But I believe that what we're doing, this forensic, is actually interested in putting our democracy right, because congruent with democratic process is the transparency and the credibility of the electoral process.
All right, let me turn my attention to laborers. And I would say, like Mr. Walker-Beer just mentioned, the judiciary was on trial. And what can our institutions do to restore confidence? And that is one question. Do not laugh. That is one question. The other question is this. Let's put it into perspective. Between 1999 and date, myriads of issues have come before the tribunal. Be it in Obasanjo's case, whereby they said he belonged, accusations were made by Olufalaye that he belonged to a particular secret organization, and some other issues that we've seen from Buhari and the rest of them, Atiku. We've never seen the tribunal overturning election results. Why is that so?
Thank you. Before I go into your question directly, I would want to quickly address the issues raised by my friend and brother here, Chris Wokobia. As a practicing lawyer that have handled election petition matters since 2003, I will not sit down here and allow a fellow lawyer claim that a judge reading a judgment and with one or two corrections in court that judgment does not belong to him. I do not know if Chris had listened or handled matters where judges will read judgment for 5 hours. I have. I also know, as a lawyer that handles election petition matters, that election petitions are not dealt with on the basis of sentiment, but on the basis of pleadings. Also, I will also say this, that everything the Court of Appeal said on the 6th on Wednesday is not novel to me, and is not novel to a lot of practitioners that have been involved in election petition. And like you rightly mentioned, the Court of Appeal and the Supreme Court in myriad of cases have said so much. So let us leave out sentiment from all of this and address as lawyers and look at the issues. Lastly, on the issues he raised, the courts, I've been reading the judgment, because even after listening to it, and I still take my time to read the entire gamut of the judgment, because what most lawyers do, they analyze judgment on the basis of newspaper reportage. We analyze judgment on the basis of law reporting. The court did not admit the testimony of the woman, not on the basis of the fact that she's a party member, but on the basis of the fact that she's coming as an expert witness that is coming to speak to a document that she did not produce as an expert. So let us quickly lay the issues, because I would also, if I expected him to even take me to the area where the court specifically mentioned her because she's a party member. That said, election petition, why has the court not been able to upturn presidential election petition? Presidential election petition generally, like we say, are sui generis, and your petition will rise and fall with your pleadings. There are also, with the restrictions of 180 days and the new amendment to the Electoral Act, even amendment of petitions are no longer allowed, and it is also sacrosanct that petitions must be filed with witness deposition. Once a petition is filed and witness deposition are subsequently front-loaded, be rest assured that those witness deposition will be discountenanced in the course of the hearing. Also, because of the requirement for presumption of regularity in favor of INEC once results are announced, as clearly stated in the Evidence Act, once you, just like section 36(5) of the 1999 Constitution, the onus is now on he who asserts to prove that indeed this presumption should be shifted. And how do you prove? It must be through witnesses that were present at the polling unit, not people who were told what happened at the polling unit. And also it must be true documents that were handed over to you at the polling unit. You are bound by time. Why file a petition knowing fully whether you cannot amend? Why file a petition and now wait for INEC to give you documents that you will now in turn file later, knowing fully well that the same document will be discounted as at the trial? So I think a proper the law, the requirement of the law on proof is so high that it is difficult to disprove between the specific time. That's why you have all of those challenges.
Right. I would like to,
to
really back in, and I want you to respond to that, because these are very serious allegations that you've put forward, Mr. Wakubia. So can you respond to that, and then we'll go to the next question?
Very strongly, let me say that in law, my brothers just talked about how